Welcome to the debate. On May 10th, the largest political opposition coalition in Nigeria might, simply cease to exist.
Yeah, and not because they lost an election.
Right. Not because they lost the support of the voters, but, well, because they lost to a calendar. We are looking at a completely unprecedented legal crisis surrounding the African Democratic Congress, the ADC, as the 2027 general elections approach.
We are. We're watching a fascinating and frankly volatile collision between the deliberate, insulated procedures of the Supreme Court and the absolute unforgiving reality of electoral deadlines.
To understand this collision, we are focusing on a highly controversial move made just days ago. On April 28, 2026, the David Mark-led faction of the ADC sent a formal letter to the Chief Justice of Nigeria, Justice Kudirat Kekere-Ekun.
Right, which was drafted by their lead counsel, a senior advocate of Nigeria.
Yes, and the letter demands that the Supreme Court deliver its judgment on the party's leadership crisis within exactly 3 days.
Which is a staggering request to make of the highest court in the land. I mean, truly.
It is, but I maintain that this letter is a legally justifiable and necessary administrative appeal, to save a fundamental constitutional right against a rigid bureaucratic clock.
And I argue that it is a coercive political maneuver, one that inappropriately pressures an independent judiciary, attempting to bypass standard judicial procedures through blatant media orchestration.
Well, let's examine the underlying mechanics driving this urgency. I look at this letter from the Mark faction, and I see pure, vital administrative necessity.
How so?
The Independent National Electoral Commission, INEC, operates on an unbreakable sequential chain. They have fixed May 10th as the absolute statutory deadline for political parties to submit their membership registers.
Right, because they need those registers to conclude primaries by May 30th.
Exactly. And INEC recently de-recognized the Mark leadership. Because of that, the ADC is entirely paralyzed. Now, the Supreme Court panel that heard this appeal back on April 22nd, they chose to reserve judgment for an unannounced date.
Which is standard procedure.
Sure, but if the Mark faction simply waits for the mail to arrive with a court date, they miss May 10th. And if they miss May 10th, the party is irreversibly excluded from the 2027 elections.
Yeah, but...
So appealing directly to the Chief Justice is, it's the only logical step left to protect the constitutional right of millions of Nigerians to freely associate and participate in the democratic process.
The problem is that what you are calling a, quote, logical step is actually a dangerous conflation of legal process and public relations. Let's look at how the Supreme Court actually operates.
Okay.
The panel heard the case and formally reserved judgment to a date of its choosing. That is the standard, conventional approach in Nigerian jurisprudence. Judges need time to deliberate, to examine the lower court rulings, to draft opinions.
But they don't have time.
I hear you. But if the Mark faction felt an emergency, the proper mechanism is to file a formal motion for expedition with the specific panel of justices hearing the case. Instead, they bypassed the panel entirely. They wrote an administrative letter directly to the Chief Justice of Nigeria, who, we should note, took over the judiciary in late 2024 and did not even sit on this specific case. And worse, it didn't quietly submit this to her chambers.
You mean the media aspect?
Exactly. They broadcasted this demand through 10 major national media outlets: Vanguard, Punch, Channels Television. They have essentially weaponized their own self-inflicted deadline to force a public institutional crisis, demanding the judiciary fix a political emergency rather than waiting for a valid legal remedy.
You characterize it as weaponizing a deadline, but I think that ignores the architecture of the electoral calendar. The phrase, justice delayed is justice denied, is usually just a philosophical concept.
Right.
But here, it is an operational, mathematical fact. The presidential election is January 2027. By law, campaigns must begin in August 2026. But the cliff edge is May 10th.
Yes, the portal closing.
Right. If the ADC cannot submit a valid membership register by May 10th, nobody can physically run in the primaries. If there are no monitored primaries, the party produces 0 legally recognized candidates. The party's effectively dead.
I see the math.
So the Mark faction isn't demanding a specific verdict. They are simply pointing out an existential mathematical certainty to the court.
Look, the mathematics of INEC's calendar are indisputable, but the assumption that the Supreme Court should hijack its own deliberative calendar to accommodate a fractured political party is deeply flawed. We have to look at the origins of this crisis.
Which is internal.
Exactly. INEC didn't arbitrarily decide to attack the ADC. The ADC is in this position because the party tore itself apart. You have the David Mark-led faction on one side and an opposing faction on the other, fighting for control. They created this mess.
But does the origin of the mess invalidate their right to a timely ruling?
The judicial system is designed to resolve disputes methodically, based on law. It is not designed to serve as an emergency cleanup crew for a political party's internal factional warfare. Why should the highest court in the land abandon its procedural integrity just because a fractured party couldn't get its house in order before the electoral clock ran out?
Because the consequence of the court ignoring the clock is the total disenfranchisement of innocent citizens. Think of the Supreme Court as a referee in a high-stakes basketball game.
Okay.
They blow the whistle to review a crucial foul on the sideline monitor. The intent is noble, right? They want to get the call perfectly right. But there's a massive problem. They forgot to stop the actual game clock while they are reviewing the tape.
Ah, I see where you're going.
The clock is relentlessly ticking down. By the time the referees step back onto the court with the correct, perfectly deliberated legal ruling, the buzzer has sounded. The game is over.
Well,
Does it matter if the players committed a messy foul to trigger the review? No. If the court's own administrative delay guarantees the total destruction of the entity seeking justice, the Chief Justice has an overriding duty to intervene and stop the clock, or in this case, issue the ruling before the buzzer.
to use your basketball analogy, the referee didn't force the players to commit the foul. But more importantly, the Chief Justice isn't the referee who blew the whistle. She isn't on the panel reviewing the tape, which brings us to the actual legitimacy of this communication channel.
Go on.
Your analogy ignores the procedural mechanics of the Supreme Court. There is absolutely no constitutional requirement or even a strong precedent for the Supreme Court to set judgment dates based on a litigant's informal administrative letter to the CJN.
It's an unprecedented situation, though.
Maybe. But when you route a demand to the Chief Justice's administrative office and simultaneously leak it to the press, you aren't engaging in legal practice. You are organizing a pressure campaign. It undermines the independence of the very panel tasked with deciding the case.
But the letter does highlight a highly specific, time-sensitive legal nuance regarding INEC's current behavior. The Mark faction is pointing out that INEC is relying heavily on the recent Court of Appeal judgment to justify derecognizing them.
Which they are.
Right. So when standard Supreme Court panel procedures lack the agility to accommodate externally imposed, unwaivable legislative deadlines, a direct administrative appeal to the head of the judiciary is arguably the only legitimate tool left. It is an administrative solution to an administrative bottleneck.
Let's actually look at that lower court ruling, because the way the Mark faction characterizes it in their letter to the CJN is incredibly selective.
In what way?
Well, their lead counsel deliberately wrote that INEC, quote, purportedly acted on the March 12th Court of Appeal judgment. That word purportedly does a massive amount of heavy lifting here. Let's explain the mechanism of what actually happened at the appellate level.
Right. The status quo order.
Exactly. The Court of Appeal did not pick a winner between the two factions. It simply ordered a status quo ante bellum. That is a legal directive to return to the exact state of affairs before the hostilities broke out.
Wait, let's walk through that mechanism carefully. If the Court of Appeal explicitly refused to pick a winner and just ordered everyone to step back, how does INEC logically justify freezing out the Mark faction entirely?
Because returning to the state before the hostilities means returning to a state where the leadership was actively contested and legally unresolved.
Okay.
If a party has no legally undisputed chairman or secretary, INEC's digital portal literally cannot accept their submissions. INEC requires authorized signatures to upload a membership register or a candidate list.
Ah, I see.
Since the lower court said, we are rewinding the clock to before this fight was settled, there is no authorized signature. INEC correctly responded to that judicial reality by derecognizing the faction until the courts provide final clarity. demanding that the Supreme Court abandon its careful review process to rush a judgment simply because the reality of the lower court ruling ruins the Mark faction's timeline is intellectually dishonest. The court's job is to interpret the law accurately, not to salvage a political timeline.
You are assuming the lower court's intervention was fundamentally valid to begin with.
What do you mean?
What the Mark faction is arguing at the Supreme Court is that the Court of Appeal had absolutely no jurisdiction to intervene in internal party affairs in the first place. This is a well-established principle in Nigerian electoral jurisprudence. Courts generally stay out of internal party leadership disputes.
Right. That is a known precedent.
So if the Supreme Court ultimately agrees and determines the lower court overstepped its jurisdiction, then INEX's current derecognition of the Mark faction is fundamentally unjust. And this is where the timeline becomes critical. Preserving the status quo ante bellum isn't a neutral, harmless pause.
It's an active freeze.
It is a condition causing active, irreversible harm every single day we inch closer to May 10. If the Supreme Court deliberates perfectly and announces on May 11th, yes, the Mark faction was right, the lower court had no jurisdiction, INEX should recognize you, it is a Pyrrhic victory. The portal is closed. The party is excluded.
I understand the stakes.
A delayed victory under these rigid statutory clocks is an actual, permanent defeat.
The risk of a Pyrrhic victory exists in almost all complex civil litigation. To elevate this specific case above all the other urgent matters currently before the Supreme Court requires us to accept that the political stakes of the ADC override the procedural integrity of the institution.
But the stakes are unprecedented.
And we must acknowledge those political stakes because they are staggering. The sheer political weight that has been mapped onto the ADC's legal structure over the last few weeks is immense. We're talking about the biggest names in Nigerian politics: Atiku Abubakar, Peter Obi, Rabiu Kwankwaso, and Rotimi Amaechi.
Exactly, the entire national opposition.
Right. We saw the Ibadan Declaration just days ago, where this massive opposition coalition explicitly committed to pooling their resources and fielding candidates through the ADC platform rather than splitting the vote.
A massive alignment.
And then immediately following that, we saw the proposal of a collegiate power-sharing framework. This framework relies entirely on the assumption that the ADC has the national spread and functional legal status to act as their mega-party vehicle for 2027.
Which absolutely validates the urgency of the letter to the Chief Justice. The scale of the political disenfranchisement would be historic.
No, I think it exposes a massive, glaring strategic failure by the coalition. How do you build a national democratic coalition's entire future on a party actively locked in a leadership dispute at the Supreme Court?
Well, they needed a vehicle.
Sure, but relying entirely on this collegiate framework and the Ibadan Declaration without having an ironclad contingency plan for the May 10 INEC deadline is political malpractice. You do not bet the entire future of the Nigerian opposition on the assumption that the Supreme Court will bypass its own procedural norms, respond to a media pressure campaign, and bail you out of a statutory deadline you knew was coming. The judicial system should not bend its rules to accommodate the poor strategic planning of political elites.
Criticizing their strategic foresight is entirely fair, but the massive scale of that coalition is exactly why this 3-day deadline matters to the country, not just to the politicians involved. We are no longer talking about the internal squabbles of the David Mark faction versus an opposing group.
Okay.
We are talking about providing a viable, robust electoral alternative for the entire nation in 2027. Millions of everyday Nigerians have subscribed to the ideals of this opposition coalition. This highlights a fascinating, almost tragic paradox of democratic design.
How so?
We are watching a system designed to protect fairness actively dismantle it. These strict INEC deadlines were legislated for a good reason. To stop ruling parties from manipulating the electoral calendar and swapping candidates at the last minute. They were designed to create order.
And they do.
But now, those exact same fairness mechanisms are functioning as a technicality that could wipe out the entire national opposition before a single citizen casts a ballot. When the highest court in the land sees that its internal administrative scheduling is about to trigger this paradox, where the rules of democracy are used to accidentally eliminate democratic choice, they cannot simply put on blinders and say, "We will rule when we rule."
But courts have to maintain order.
Courts operate within a society.
They must recognize when their procedural calendar threatens the very fabric of democratic participation.
But the fabric of democratic participation is held together by the rule of law and the independence of our institutions. If the Supreme Court yields to a 3-day ultimatum delivered via the front pages of national newspapers, consider the precedent that sets.
I don't think it's a dangerous precedent.
Really, the opposing faction is watching this timeline too. If the Chief Justice caves to media pressure and forces the panel to rush a ruling, and they rule against the Mark faction, what happens next? The opposing faction realizes their primary window is just as narrow. Do they then get to write administrative letters demanding 24-hour turnarounds from INEC?
That's a slippery slope argument.
By entertaining this media-driven pressure campaign, we risk turning the highest court in the land into a reactionary body. We signal to every politician in the country that the way to get expedited justice isn't to file a compelling legal motion, it's to buy front-page ads in Vanguard and command the most column inches.
The media isn't creating the pressure, though. The media is simply illuminating a structural reality that already exists. It comes down to this. When rigid, unyielding electoral clocks threaten to disenfranchise millions of voters and dismantle legitimate, massive political coalitions on a technicality, urgent administrative appeals to the judiciary are not a subversion of the process.
I still disagree.
They are a necessary, justified defense of constitutional rights. The law must function as a shield for democratic participation, not a bureaucratic trapdoor that swallows the opposition whole.
And my position remains that while the political stakes are undeniably high, allowing litigants to use orchestrated public pressure campaigns to dictate Supreme Court timelines undermines the very core of judicial independence.
Even when the clock is running out.
Yes, it establishes a dangerous norm where procedural integrity is routinely bypassed for political convenience. If this grand opposition coalition fails because they lack the foresight to plan around a known legislative deadline, that is a failure of politics. It is not a failure of the courts, and the courts shouldn't break their own rules to fix it.
Well, we clearly diverge on whether the Mark faction's letter to the Chief Justice was an appropriate mechanism. But looking at the broader picture, we arrive at a critical point of convergence. Regardless of whether you view this letter as a vital democratic lifeline or a coercive public relations stunt, the structural reality on the ground remains identical.
Absolutely. The entire strategy of the Nigerian opposition currently rests on a knife's edge. From the grand ambitions of the Ibadan Declaration to the intricate mechanics of the collegiate power-sharing agreement, every single piece of their 2027 roadmap hinges entirely on what the Supreme Court chooses to do, or, chooses not to do, over the next 72 hours.
The intersection of strict electoral law, rigid administrative deadlines, and high-stakes political strategy has created a perfect storm. Every link in this sequential chain depends on the one before it. Right now, the entire country is waiting to see if the Supreme Court will forge that first link before the buzzer sounds.
The law has its deliberate pace, but the electoral calendar has its absolute demands.
Exactly. What happens if May 10th passes without a ruling? Does the deadline only take out the African Democratic Congress, or does it take a crucial piece of Nigeria's 2027 democratic process down with it? We leave that for you, the listener, to consider. Until next time, keep questioning.